When her friends got involved, that's when she said I couldn't see my kid. She went as far as blocking me electronically where I can't contact my son at all. You only want me to talk to him when
Okay.
he's in trouble.
In Your Honor, we ask that you take judicial notice of the child support review order that's attached there to where it takes judgment for medical of 560.86 as of January 31, 2025. The gross is calculated at 3828. One child herein, two children outside. $100 towards the government health plan. At 16%, the current ongoing child support will be modified to 503 starting March 1, 2025. We ask that you take judicial notice of these provisions.
The court will take judicial notice that the proposed non-agreed has a medical support judgment of $560.86. It proposes that medical support be set at $100 a month beginning March 1st with government health insurance, and that with the guideline amount in the order, the child support is set at 503 beginning March 1st.
Thank you, Honor. State calls Ms. Gibson.
Yes.
Ms. Gibson, can you state your name for the record?
Yes, Kelandria Gibson.
Ms. Gibson, this order that the judge took judicial notice of, you signed this order correctly, right?
Yes.
Okay. And you're requesting everything that what's in the order, ma'am?
Yes.
Now the child support is set at 503 a month, and you're saying that that's what you're requesting. That's what you want, right?
Yes.
Okay.
We're immediately thrown into a father's frustration as he claims he's been blocked from contacting his son, setting a deeply emotional tone. But the courtroom quickly shifts focus to the real issue, money. The court lays out a proposed increase in child support, jumping from a long-standing low payment to a much higher amount. The mother firmly agrees, making it clear she wants this change. Right away, you can feel this isn't just about finances. It's about control, access, and unresolved conflict.
Your Honor, pass the witness.
Mr. Zahay, do you have any questions of Ms. Gibson?
Yes, I do, Judge. Ms. Gibson, do you believe that, or excuse me, is there any particular reason that you believe this increase is needed in accordance with the guidelines?
Yes, it's needed. I mean, he's only been paying $186 a month for the past 9 years. So it is time for the increase, and there's nothing done in between those 9 years outside of the child support or anything. And $186 a month is not enough to take care of a child, even when he was in daycare. Like, that's just pays for daycare, nothing else.
So did you ever indicate to Mr. Jones and his wife that you had other motives for asking for this increase?
No, I did not. They asked for the court. They said they wanted to do court arrangements and they were going to go to the court and do everything by court. So that's what I did.
So
we can go by the court orders and the court papers.
So it's not true that you told Mr. Jones and his wife that this was in retaliation for them being married recently?
I never told them that I was going to get an increase for retaliation. When they brought up to me, I already have an attorney, so you'll talk to my attorney. I said, okay, well then, yes, we can go to attorney, we can go to court, and we can set these obligations or whatever it is that you're asking.
Didn't you instruct one of your friends to show her a group chat that you guys had created disparaging her?
A group chat? It had nothing to do with the kids at all.
So do you need a a screenshot of the chat to refresh your recollection?
No, I do not. The screenshot, the group message had nothing to do with the kids. That was all stuff that was outside, basically stating that he does not do anything and that he hasn't done anything for his child in the past 9 years. That's basically what the whole group chat was about. Yes, and enough is enough. And he has to start paying and being responsible, just like me. When I lose anything or when things go bad with me or anything like that, I'm a mother. I still have to make sure my child is still taken care of at the end of the day. He don't have to worry about that. And he's been getting off for literally 9 years. So I gave him 9 years of slack. It was going to be an increase regardless of any situation at some point. And he started the group chat in the beginning because at the beginning, he's the one said, from now on, you would be speaking to me and my wife in the group chat if you have any concerns about anything. And that's what I did. And that's how the group chat started.
And in that group chat, you had said that, is it true that you said that part of the reason for these proceedings is that you wanted to come after the assets of his wife?
I didn't say that. Those were words from my friends. Those did not come out my mouth.
And she said,
Now we see the mother take center stage, and she doesn't hold back. She argues that for nearly a decade, the father has contributed very little, insisting that $186 a month barely covered basic needs. The tension spikes as accusations of hidden motive surface, including claims about jealousy and targeting assets. She shuts that down, but the introduction of a group chat drama adds another layer of conflict. At this point, it becomes clear this isn't just a legal dispute. It's personal, emotional, and deeply complicated.
That after these proceedings, she would own that, pardon my French, own that B word.
Now, is my name on the side of that?
Yes, I can show it to you. You're in that chat.
No, I said, did I say that? Is my name that said that in the chat?
Your name is in the chat.
I may be in the chat, but I did not say that.
Oh, but
that has nothing to do. I can't control what other people says or what their obligations are.
Pass the witness.
Any other follow-up, Mr. Darkomanjian?
No, Your Honor.
You may call your next witness.
Thank you, Your Honor. State calls Mr. Kevin Jones. Mr. Jones, can you state your name for the record?
Kevin Jones, Sr.
Now, Mr. Jones, you provided your W-2 from 2024, isn't that right?
Yes, sir.
Okay. Now, Your Honor, may I share his W-2?
You may share your screen.
Now, Mr. Jones, is this your W-2 that you provided to the state?
Yes, sir.
Okay, and where do you work, sir?
Owls Services.
And what do you do there, sir?
I'm a gas technician. So I change filters and calibrate gas stations across the United States.
Okay. And how long you been working there?
13 months. I want to say February of last year.
Okay. And your wage tips and other comp on this W-2 is $44,039.26. Isn't that right?
Yes, sir.
And your Social Security wages is $45,939.09, right?
Yes, sir.
Okay. And you still work there as today, right?
Yes, sir. I'm at work right now.
Okay. I'm going to stop sharing, Your Honor. Your Honor, at this time, I pass the witness.
Mr. Zahay, you may, any questions for your client?
Yes, Judge. May I proceed?
Yes.
All right, Mr. Jones. Now, in our talks, you said one of the things you wanted the court to consider was the costs that you have to expend in order to travel and see your child. Is that correct?
Yes, sir. When she allows it.
Can you tell me how? Let me backtrack for a second. How often are you able to see your child?
Well, according to the reason she allows me to see my son, depending on the mood, or if he's available, or if he doesn't have summer school or something like that. She's only denied me to see my child this past last year. And
Assumption was, as far as what you said about not being able to see him due to your financial constraints.
well, it's the cost that like personally, if I go pick up Carson by himself, it's at least 150 to $200. That's 4 hours that way, because she's never met me outside of 3 miles outside of her house to pick him up. That's 4 hours there and then 4 hours back to my house. So it's around like $200 with gas and a hotel, because if I leave, I can't drive at night. And the increase, I'm not opposed to the increase at all, but I think the amount of the increase is a little bit excessive. Man, that's because like I won't be able to see my son as much, especially if I'm not seeing him now. I won't be able to see him as much. And it's basically kind of like it's going to prevent me even more, and it's going to affect my other two kids as well, as far as me coming to see them.
Where do you currently live? What city?
In Mesquite, Texas.
Does your son Carson currently live?
And Rosharon, the last time, Rosharon.
As far as that,
about 4.5 hours from my house to her house.
if you're traveling, which you often do for your job, it would be even
more.
further
So
distance.
yeah, the last time I came, I want to say I came from Oklahoma, and
Here's where the narrative starts to shift. The father steps in to defend himself, and suddenly, the situation isn't as one-sided as it seemed. He explains the long distances, the heavy travel costs, and how seeing his son can cost hundreds each time. He insists he's not against paying more, but says the increase could make visits even harder. He also claims he contributes extra when he can and lacks communication from a mother. Now the story feels layered, less about blame, more about conflicting
had to be
realities.
out of my pocket to travel from Oklahoma to back to Houston to come get him. I want to say the last time I was allowed to come get him. And I had another thing to mention about that group chat, because I told her, the only reason why I told her to contact my wife, because it was a situation where she had called too late, and that had kind of set, the tone in my house with my wife. I didn't start the group message with her friends. I didn't even know her friends existed. I don't exactly remember how the situation came up, but it was, because I didn't have a lawyer at the time, and what happened was they came threatening to, they basically wanted to go after my wife's assets. And I guess when they found that it wasn't a case, because she says I never done anything but pay that 183. Last year, I just gave her $500 through the child support payment thing. You could see that. I mean, that's on there. So it's not like when I don't have extra money, I'm not trying to get out the hole, because I still pay extra money. I have text messages to where the year before last, when she asked my wife for money for school shopping, we did it. If she asks for something, we try our hardest to get it, but she doesn't ask for anything. She doesn't inform me, oh, we need this or we need that. She just automatically assumes that I'm just supposed to assume what she needs in her household, and I have no idea what she does in her household. I don't know if she works. I don't know what she does, or whatever it is that she has going on, or quote unquote, like she says, she has to survive. Whatever that means, I have to survive as well. And I have two other kids before that. I don't like it's the distance between us that I have to travel from my job to even survive. Because without me going out of town to work, basically with this child support I won't survive.
The court was to take into consideration the expenses it costs for you to travel and see your kid. How would that help you see
I
your
could get
kid?
I could get to him more than two times a year. That would help me get to him more than 2 times a year, or actually help him get him for whenever he's allowed to come. It's when her friends got involved, that's when she said I couldn't see my kid. She went as far as blocking me electronically where I can't contact my son at all. So I understand if me and her can't come to an agreement on a financial thing, but I know this is not where you bring up court things, but it's the whole electronic, like you blocked me from his phone so I can't contact him.
Judge, I want to pass the witness, but before I pass the witness, I do want the court to take notice that under section 154.123, section B, excuse me, it's B, I'm trying to find the number. It's B14, section 154.123. B14 of the Family Code, the court can take into consideration the cost of travel in order to exercise possession of and access to a child in order to deviate lower than the guidelines.
Okay. Thank you. I'll take judicial notice of that. Ms. Gibson, do you have any questions of Mr. Jones based on his testimony?
So unfortunately, I mean, no, I don't really have anything to say because
And this is just your opportunity to ask questions. In a minute, I'm going to let you tell me what you want out of the
okay, then no, I don't have any questions.
Okay. So, Mr. Jones, I'm just confused because are you having trouble right now visiting with your son?
What happened was she contacted the other mother of my child.
No, here, let me clarify.
Okay. I am. Yes, I do have trouble contacting my child.
Okay. Well, I get that. Let me clarify what I meant. You said that if your child support was increased, you would not be able to visit with your son.
I wouldn't be able to afford to.
Okay, right now your child support is based off of minimum wage, which is the baseline.
Yes, ma'am.
Are you able to visit with your son and travel to pick him up now?
With the thing that I have going, yes, ma'am, I am.
How often do you see your son?
What I could physically afford myself, probably twice a year. And if the increase, yeah, it is.
So, Mr. Jones, what I'm hearing is right now, based off of minimum wage, you can't afford to visit with your son.
No, ma'am, I can't afford it personally.
So, okay, even before the increase.
Yes, ma'am. I'm not disagreeing with the increase. I just said the amount of
Kevin, one second. But it would be exacerbated, is what we're saying.
Yeah.
Okay. Okay. Mr. Darkamanjian, do you have anything else?
No, Your Honor, just a brief closing.
Okay, you may proceed.
Your Honor, what we've done is we've taken the $45,939.09 and divided it by 12 to get to the gross figure of $38.28 to calculate what his current child support should be after the one child herein and two children outside this case, and the $100 towards the government to help plan. And we ask that you approve our guideline as calculated.
Mr. Zahay, any closing?
Yes, Judge. So, as mentioned, Section 154.123 of the Texas Family Code, Section B14 says the court can take into consideration the cost of travel in order to exercise possession of and access to a child as a factor to deviate from the guidelines to a lower amount. Now, before I even get into that, I want to say that Mr. Jones is aware that there is going to be an increase. He is okay with there being an increase. He wants there to be an increase. He wants to help his child. But all he's asking is just for the court to take this into consideration. He lives 4 hours away from his child. He travels often for his job, as mentioned. So half the time, if he wants to see his child, is even farther than 4 hours to go see him and cost even more money to go see him. He just wants this. He just wants the court to take this into consideration. It doesn't have to be a unreasonable or huge deviation, but just some accounting for this. for the court to deviate lower than the guidelines. If the legislature specifically listed it, I would say that it's a pretty important factor to consider. So we just, respectfully request the court take this into consideration before rendering an order.
Ms. Gibson, what would you like to tell me before I make my ruling in your case?
Again, as far as I just do want to speak on the travel thing, like I said, it's been 9 years. He does not take the effort to come and see his kid, and he's always had access to Carson. I've never cut anything off. I've never had any restrictions on him except for this last time. Yes, I did. There was purposes of that, but like I said, he's had several times to come and visit him. But like I said, it's only when it's convenient for him. It's never just, oh, I want to get my child, just, spend time with him or the weekends or anything like that when he is available. So like I said, so the traveling and the money and all of that, that's not going to, because he wasn't doing it before. So I don't feel like he's going to do it moving further.
Well, he was doing it until she blocked him. I just want to put that out there.
I didn't block him, but my son has a phone and he's always had access to him. The only reason why it's been off is because he has been on punishment. But he still has access to my phone, just like he's talked to him the other day when he called my phone. I did let him talk to him. But he does not call him as well that much. So
You only want me to talk to him when
Okay.
he's in trouble.
Okay, guys, I've heard enough at this
Yeah,
point.
okay.
Okay, Mr. Darkamanjian,
This is the turning point. Both sides make their final arguments, each trying to sway the court's perspective. The father's side pushes for fairness, emphasizing travel costs, while the mother questions his consistency and effort. Then the judge steps in, carefully balancing both arguments. The final decision lands somewhere in the middle, reducing the payment slightly while still increasing support overall. On top of that, strict communication rules are enforced to prevent further chaos. It's a measured ending to a highly emotional case. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.
help me out with a little math, okay?
Yes, Your Honor.
If I put the medical support at $50 instead of $100, what is child support?
If we do the 3828 gross a month,
Mm-hmm.
one child here and two children outside this case, $50 towards the government health plan, then the multifamily child support guideline will be $511 a month.
The court has heard the testimony of all the parties. I am going to approve the judgment amount in the non-agreed order for the medical support of $560.86 as of January 31st of 2025. And Mr. Jones, you're going to pay that at $55 a month beginning March 1st. I do find that you have gross wages of $3,828 with one child before the court and two other children that you support. I am going to modify your medical support payment to $50 a month beginning March 1st of 2025 instead of the $100. So that would put your child support at $511. And what I'm going to do is I'm going to reduce that by $75 for the gas money, for half of the gas money it takes to get to visit your son. So your child support is going to be $436 a month. That's also going to start March 1st of 2025. Any court costs in this matter are billed to Mr. Jones. He can pay the Brazoria County Clerk's office if they even bill him for them. The other thing I'm going to do, just because of the testimony I've heard, I'm going to order that you, Ms. Gibson and Mr. Jones, need to communicate through the AppClose app. Y'all do not need to be communicating with third parties in a group chat with people claiming things. It just needs to be between the two of you. So I'm going to order that y'all communicate between AppClose. It's an app you can download on your phone. That way, in the future, if you need to come back and provide any proof, you've got everything in your one app. Ms. Gibson can also put any, extracurricular activity calendars, school calendars, things like that there. So you, Mr. Jones, can see everything. She can also update it with any doctor's appointments, things like that. So you both have information regarding your child. Okay?
Yes, ma'am.
This is going to be the ruling of the court. I'm going to have you go back into the breakout room. Mr. Darkamanjian is just going to amend the order, have you look at it, sign it, and then you'll both all be excused. He'll answer any additional questions you have as well.
Okay. May I go tell my foreman that I'm about to be done with this court case right now?
Yes, Mr. Jones.
Okay.
Before you walk off, let me move you to your breakout room real quick. I'm going to put you in room 25, Mr. Jones.
Yes, ma'am.
Same for you, Mr. Zahay. And then Miss Gibson, I'm going to move you to room 26. There you go, ma'am.